Hello, everybody. Hello, welcome. I'm a little bit behind today. It's been a busy day, but welcome in. Happy Monday. Just finishing getting my last pieces set up here. Hello, welcome. Welcome, everybody. Welcome in. Good to see you all. I'm wishing and hoping you all had a great day. Hello. Happy Monday. Yes, it's been a busy day. It's been a busy day. Do you think we'll ever see another constitutional amendment? Absolutely, it's possible. It is possible. I think we just all need to come together. Once we're able to come together again, I think we will definitely see that. We definitely have a few that could go. Hello, Cody. Good to see you. Welcome. Hello, Stephanie. We have a couple of amendments that definitely, I would say, probably congressional term limits is probably one of the big ones that could be. Another one would be judicial term limits for the Supreme Court. That could be another one. So we have, I think, a few things that we could definitely talk about. So hear about the lawyer on Lou Dobbs? No, I've not. But I have been kind of buried in this trial today, so I may have missed it. Really? Oh, cat juice, come on. Women's rights. Yeah, absolutely. Now, we don't actually have to have an amendment in order for women's rights to come in, but of course we have the Equal Rights Amendment, the ERA, that has been sitting in the wings for a very, very long time. That's not been passed yet, but could pass at some point, someday. If found guilty of a crime, is one unable to be present? That would be a great addition to the Constitution, correct? I would support that. Transcripts are now available. Okay. All right, hold on. For every day. Now, really, because I've been looking, and it looked like they were only available for, it depended on, if you had the right credentials or the right questions, but are they now available, everyone? Oh my goodness. Oh my gosh. On the day after. All right. So I will keep my eye out for that. If those are available, that will really be, they are available. Oh my gosh. Oh, that's super fun. You know how I feel about transcripts, everybody. That'll be great. Attorney Dave told us, okay. Well, that sounds great. I knew that they were fighting it. I'd even seen there had been even just today something that had been published asking them to release it for everyone else. So we definitely need them. Absolutely. Charged for contempt like U.S. regular citizens. Well, it depends. Contempt and all of these kinds of cases, we've got rules we've got to follow. We do have a hearing set for tomorrow morning, so we'll see if something happens there. But it's a Mystic, I think it's Mystic Topaz. I believe that's what this one is. I'll need more toner. I really will. I will need a lot more toner. If I get my hands on those transcripts, though, everyone, that would be fantastic. That would be, yeah, lobby for the ERA in the 1960s. I know, and we still don't have it yet. It's still not there. So, we're still working on it. We did get an amendment passed in the 90s. That was the most recent amendment, and that has to do with Congress giving itself raises. But that was the most recent one. So before that, we had voting at the age of 18, down from 21, which was set out in the 14th Amendment. So I'm doing okay today, Cozy. Thanks for asking. Appreciate that. It's been an interesting day today, but immunity arguments on Thursday, absolutely. It's going to be very interesting. Lots of different ways it could fall. I think it's worth the time that it's going to take to listen to the arguments. I think we all need kind of a minute to check in. So great question. I have here a few drawings that I was able to, I got these online through different media sources. So these are not anything that, I created. Of course, I wouldn't have this level of talent by any means, but these are some diagrams that had been set out to give everyone an idea of what the courtroom looks like there in in New York. So this is actually the jury box here, but I think they were using this as a way to kind of illustrate that the alternates are separated. So they are set out, 1 to 12, and then we have 6 alternates here. But I think they're sat actually here. I don't think they're necessarily in front of them. We love the art. Oh, thanks. I love the art too, from the very talented artist that created. So, which is not myself, which is not me, but they do great work. 16 chairs in the second drawing, right? So, yeah, and so I think what happens is they have it set out. Now, again, I don't know the specifics when it comes to how New York sets things up. This is very similar to my own court that I just have down the road, but very similar. Although this table here is actually it's very similar. This would be more. We have more support kind of up here next to our judge as opposed to back here. But yes, our paralegals and our supports sit here, and then we have the state usually is on this side, and defense counsel's usually on this side, depending on what kind of a hearing is going on. So, and we have, I think I've told you before, we have doors usually that swing here. We don't have any kind of a bailiff or anyone really with any law enforcement background for most of the hearings, unless we have someone who's actually in custody. We just, we can't afford it. So we're lucky if we have a judge. So out in the sticks, you're lucky if you have a judge when you need one. So yes, I do have the sharpest viewers. I most certainly do. I'm so thankful. I just love coming in and hanging out in the chat too with everyone. So yeah, this is a great diagram, I think, of how New York is set up. Of course, it's going to be huge, and I always am sometimes overwhelmed by how big some of the jurisdictions are. My jurisdiction certainly is not this big by any means, but when you look at some of these, you're like, whoa, my goodness. But this is a really good one. I have not seen the transcripts yet, everyone. I'm going to be looking for them, though. That's huge. That would be a huge turn of events if we do actually. Where are the... Now, I have this diagram here that has kind of put them out here. So we have here, and then we have 6 set. But it looks to me in this like we've got them kind of... they'll be numbered somehow, and then at the end, after 12, then the alternates will be seated after them, is what I would assume. Hello, Kristen. Welcome. Good to see you. They'll be put out the next day. Okay, they're releasing transcripts daily. Oh my gosh, everyone. That is very exciting. I'm glad I got a brand new toner cartridge today. So... the juror seats have no numbers. Okay, well, and that's something that I think is really interesting in New York. They do things a little bit differently there, and they've got 2 rows here, which makes sense. And again, how they're set up is going to just kind of depend in that situation. Going to see me a lot more. Well, I think so. The ASMR. Well, Kristen, I promised to give you a little ASMR. I was so thankful for all the gifts that were sent in last night. I was able to get my blue ink, so I had to share that. Oh my goodness. All right, so welcome in, everybody. Welcome in. I've just got a few diagrams here that I wanted to kind of share with everyone. We do have some fun, interesting things that went down today in court with our oral arguments, as well as some decisions that were made regarding the Sandoval motion, which I'll talk about a little bit more. So as for these sketches, I do have actual pictures of the courtroom as well. So let me share that. And this is one of them. So we've got 1, 2, 3, 4, 5, 6. 2, 3, 4, 5, 6. So right, we've got 6, and I'm wondering if the alternates go back here. Again, we don't have a full view here, but it looks like they can maybe fit back here or in the front. That's just not something. Yeah, the witnesses will be seated next to the judge at some point once we get going there. Yes, they do, like old chalk outlines. I agree. Here's another view again. So, and we can see here, I don't see the alternates set in here. So, my guess would be, and how our court is set up is that they're all mixed together in the jury box. So they would be all included here. We'd have 18 in here rather than 12. So I'm assuming that's kind of what's happening here, but it's kind of hard to tell. Again, we're just kind of getting a little bit of a peek inside. Yes, the witnesses are very close. That's one thing I think a lot of people may not realize is how close everything is when we go into a courtroom. Like it's not like a huge auditorium. To some degree, I suppose it is. Because there is seating back here, and seating's behind. But this is really where it all goes down. And if you look at how things are spaced, here we've got witnesses, we've got our court reporter who's going to be sitting in here. I'm assuming the court reporter is here. Sometimes the court reporter will be here, and we also have, sometimes the judge will have someone sitting next to them that helps them out as well. But if you take a look at this, if this is defense counsel's table here and this is the state, look how close the defendant is to the witness. And that can really be intimidating. And if we remember the E. Jean Carroll case, she was talking about how she was sitting, right here and Mr. Trump was right there. And it was, she was really worried about it, and rightfully so, because there's not a lot of room. Now, is something ridiculous going to happen? Probably not, but still, it's kind of that idea of sitting there and facing that person that's done so much harm. So it can be very, very difficult. Jackson, did you really get access? Okay, well, I will have to take a look. I looked around before I came on tonight. The room's cramped, the building's old. Yes, and again, kind of think of it like an old basement kind of, or old school situation, because our courthouses, everybody, like, we have no money in the courts. You can tell how much money we have by how much money our judges make, which is nothing. They make like no money. They get no raises. Our prosecutors over here, they get raises if they're lucky, but it's all county-wise, so they have to put it into their budget, and their budgets get cut pretty tight. So we, for as much as it's in the movies, it's just not like that in real life. We just don't have the funds for it. So, good Lord, yes, Secret Service, I think, is going to be, from what I've seen, is kind of around in and around the situation, and here, because you can kind of take a look. This was an actual photograph from today to give you another kind of perspective, and you can see how we've got Mr. Trump and his attorneys here. So the state's going to be off to the side. We've got police, and then I have no doubt we have Secret Service just kind of out and about in the area. Well, all kinds of men fall asleep, innocent as well as guilty. So I'm not sure that's a necessarily good litmus test for who's innocent and not. It's interesting and odd how the body reacts to stress and anxiety in all situations. So there's really not one rule that kind of works for everybody here. The old school courtroom. Right, it does. Well, I mean, we're in New York, and New York, as much as they do their best, of course, again, our justice system is so short on funds that it doesn't matter where you're at, unless you're in a super, super wealthy county, you're still going to struggle with your funds. Will the jury have security? Great question. I'm not sure. I think that they are allowed to go home at night, so there is that, and I think if they've got security concerns, that will be addressed, but we don't have it up at this point. I have not seen that. I have a sleep disorder, and I can't stay awake when I'm stressed. My body shuts down. Oh, absolutely. I have a dear friend here local that also has a sleep disorder, and bless her heart, sometimes she just can't manage it, but sometimes you would think that, though. You would think, like, wow, if you're in something this serious, you got to be staying awake, but you just never know what's going to happen. Really, all bets are off. That's why I always say It's 50-50 shot when you have a jury because you just never know what's going to happen. The same with courtroom behavior. You just want, until you're in there doing it, and repetition helps. So as trial attorneys, we go in over and over and over again. We're used to our courtroom. We know what to expect. We've put our bodies through it many times before, so we know it's kind of a muscle memory situation. So, we leave everything behind us once we walk through. Basically, once we walk through here as trial attorneys, like nothing, it's done. Now everything is done. Like we don't even have bodies anymore. We're all just doing our case up here, and so we just don't even look back. But if you're not doing that all the time, there's just no way to prepare yourself for it. Can the Secret Service be asked to testify for any of these cases? Great question, and I don't see why not. I mean, the Secret Service is a service that is given. They're not like, in a confessional or doctored patient. I mean, they don't have the kind of privilege that's been accepted in the rules of evidence that I've ever seen as Secret Service people. So, attorney-client, doctor-patient, psychiatrist-patient, even a dentist-patient. You can have those kinds of situations, and then of course a religious leader person and another person, although that's pretty specific just to confessionals, so that's kind of questionable as well. But as far as Secret Service goes, nope, I don't see any of that. So right here, I've just got some diagrams that have been made available online to just kind of give us an idea of what things look like. Here we've got the jury and the alternates. I don't believe they're actually sitting like this, but this gives us kind of a visual that we've got 18 people. This is the visual of the courtroom where we have the jury, we have the judge here, we have the state and defense counsel, and we have their assistants, so assistant DAs or paralegals as well here. They have in this room, it's pictured that we've got our court reporter sitting here. And the court reporter can be up here usually in my jurisdiction. She's even right here. Typically, it's not always a woman, but I've never seen anyone that's not a woman that's been a court reporter so far. If Mr. Trump really does smell terrible, can the judge do something about it? Yes, if it's something that's disturbing the proceedings, the judge can take appropriate actions. But, this isn't the first time. If we're dealing with a true medical situation, if there's medical issues going on, of course the judge is like, let's accommodate, let's do what we need to do to take care of business. But if we just have something that's inconvenient and unfortunate, that's kind of a different game. Sometimes, you'll have defendants or you'll have people in court that have weird reactions to this kind of level of stress, and so it can just be really uncomfortable for everybody involved and unfortunate. I have to say, one of the hardest things that I remember doing was, and I don't want to give away my location, but we used to have a very large, well, we do have a very large university in the town that I live in, and there's a huge celebration. And after this celebration, of course, a lot of people were arrested. So the next morning they had to come in. And so I remember volunteering, because I was an idiot, volunteering for duty the next morning. And so as a prosecutor, and luckily I had a friend, another co-prosecutor with me. So we had 300 people just coming out of the drunk tank lining up. And if you want to see a bad situation, that's like, there were just not enough garbage cans for everybody. The room smelled like a brewery. There was all kinds of bad stuff going on, and we're just over here trying to handle it. And because every single time someone would come up, I would go up. We split the number of people. So he did half and I did half, and so we would go up. And there's even one time when someone just got sick all over the bench, and sometimes it gets pretty ugly. This is just real life. Sometimes that can happen. There was another courtroom that I was in quite frequently, and there were teeth marks on the bench. And I had asked the judge, I was like, Your Honor, what's going on with the teeth, with the bite marks? And he had told me, one of the defendants had passed out and hit his head on the bench, and just there was, all kinds of you can imagine, I have to be careful with my language here, but I have PTSD from night court. So true. Oh my gosh. If you're in a college town and you are, and you're showing up after the big game to be like, hey, how'd you do? It can be very, very, very difficult indeed. But nothing will ever match the giant party that this university in my town had. And so the judge has seen it all. So it happens, everybody. It happens. And I think one time the judge said we need to get more trash cans in here. And the police, we did have police because there were so many people. And the police were like, we don't have any more trash cans. And he's like, just bring bags. So it can be a lot. It can be a lot. Oh my gosh. So, it depends on what happens, everybody. If the judge feels like something needs to be taken care of, it's his courtroom, it's his show, it's his house. He can do whatever it is that he needs to do. So, if he finds this to become a real issue, then absolutely he can step in. So that's a long answer to a quick, short question. So let's go ahead, everybody. And you just never know what's going to happen. We'll dive in. As a quick friendly reminder, I do like to give a shout out here to our 3 primary courtroom sketch artists. We do have some more sketches today, and let me make sure I get their names correctly. So this one is Christine Cornell, and then we have Jane Rosenberg here, and then we have Elizabeth Williams here. So I don't know that they are all of the courtroom sketch artists, but they are the 3 primary one that they've been doing it for a very long time following Mr. Trump and his trials. So I just want to kind of give a shout out here to these amazing creators, and we're very thankful for their sketches so we can get kind of a peek into the courtroom. Once the proceedings start, of course, all cameras are done, so we've got no way to have that kind of information. So we're very grateful to give us kind of an inside view of that. So with that, everyone, we did have a busy day. there was finger pointing. Now this is his own attorney. So let's get started and kind of talk a little bit about what happened today. And again, I'll kind of take you through very similar to how I've done it the previous couple of times, the previous times when I went through and just kind of took you through the day here. And there were some interesting things that happened and some, just regular housekeeping work that went down as well. So how I gather this information, of course, because none of us are in the room, is I tend to look at multiple different sources and I just compare what they're reporting. I compare what the quotes are and then kind of put it together and eliminate what I think isn't quite right and then come back in with what I think is the most accurate depiction of what's happened in the courtroom. So that's where I'm getting my information, is just from multiple places where people are actually in the courtroom and they're reporting what's going on here. So let's go ahead and get started then with the beginning of the day. And I do have some other previous sketches that I'll kind of sprinkle in as well. Some of my favorite ones here that I think are just so good at telling the story of what's happened in court. All right, so here we go. Let's get started. Oh my gosh. Yes, indeed. My moderators are just some of the best people ever that I have ever known. I'm very thankful for their hard work. So here we go, everyone. The judge did come in and explained that he had received a call from one of the jurors because one of the jurors had some concerns about the media attention that continued to go on. So he had said, they spoke and counsel went up. They spoke to the juror about it. They decided, and the juror is fine. The juror is going to stay on. But again, that was something that Judge Mershon wanted to address right away. So he did take care of that immediately. Also, he explained that court was going to be done today at 12:30 because one of the jurors had an emergency, a dental situation, and they had scheduled their appointment for 3 or 3:30, I think, but the dentist was like, no, we got to get you in sooner. So the judge was like, we can do that. And sometimes these kinds of things happen. Yes, the court transcripts. Yes, indeed. I will be hunting for those later. For sure. For sure. So yes, I will be leaving the descriptions of the jurors pretty vague just because I don't think it's necessary to really tell the story here. So with that, he did say we would be done at 12:30, and they did finish today at 12:30. So that can happen, absolutely. So he did then ask both the state and defense counsel, how long do you think your opening statements are going to be? Defense counsel said they need about 25 minutes. The state said we would like to have about an hour. And that's pretty normal. I think an hour is about right. An hour is getting a bit long. Now, as I go through, I will give you excerpts from both of the oral arguments, but as we go through, there are some direct quotes that the state presents, so I think I can see why it took them a little bit longer. Oh, absolutely, Lexi, absolutely, of course. Yeah, I'm just here to explain the process. I'm not, again, the most important people in the courtroom are the jury, so, I mean, that's absolutely number one priority. So, 25 minutes is a long time to say, well, they can stretch it out. And they did. I think they did an okay job. But so he did ask that, and those were the estimates. Now, D.A. Bragg was in the courtroom today, everyone. He was not in the courtroom previously, but he was today. And it was noted that there were no family in the courtroom for Mr. Trump. I don't know if that's important or not. I don't know that I would want my family in the courtroom in this kind of a case. In fact, I would tell them not to come. But, some people are reporting that, and some people think that that's interesting. So, thank you very much. All right, so we started this whole proceeding. Okay, we've always got to do some housekeeping in the mornings. So the judge had a ruling that he read. Now, I have not seen his order. Again, and I try to come to you with specific orders, but the order has just not been, filed yet. So it will be at some point. But there was a question about the Sandoval hearing. And Sandoval in New York is where the state says if Mr. Trump decides to testify, this is his prior bad acts or other bad acts that we would like to use in that situation. Do they need to wait all night to get in? I think that they have special credentials to get in. I think that's how it works. So here, you didn't like the prosecution's angle. Yeah, and I think there's a lot of things to talk about, a lot of things in there. So with this, the judge came out and he just read his order. He read what he had agreed to. So the state had filed this, which was basically their request of what they wanted to use against Mr. Trump if he testifies. So this is only if he chooses to testify. He does not have to testify. It's his right to testify, but he certainly doesn't have to by any means. If he chooses to testify, then the state said, these are the things we want to use, and they're trying to get permission from the judge ahead of time. Can the family members attend if they will be called to testify? Great question. And if there is no request that witnesses are being sequestered, which, I don't have any information on whether or not they will be sequestered, then they can. If they have to be sequestered, then they wouldn't be able to listen to the testimony of the other witnesses. So it would depend on what role they would play. So several of the things that the state requested were allowed in, several were not. The judge felt that there were several pieces here that were just too prejudicial. Now, we've talked about this before. When you have something that's probative and helpful, but it's too prejudicial, or the jury will focus on that too much as opposed to everything they need to look at, the judge then has to toss it. It just has to be tossed out In federal court, we would call that a 403 issue, a 403 objection, but here we're in state court. So he did say there were a couple of things okay. So let me go through this real quick. I think there's just a couple things. So we have the James v. Trump case, and this was the determination was in February, and we've got just the basic underlying facts of this. So defendant repeatedly and persistently falsified business records, conspired to falsify business records, issue fake financial statements, conspired to issue fake financial statements, and conspired to commit insurance fraud by fraudulently misstating the value of his assets for economic benefit. That's it. Now, there's a lot more information that is involved in this case, but the judge is like, we don't need to go down the whole road. This will be enough to set out that there was some fraud involved. That's been pre-approved. So we also have defendant testified untruthfully under oath. The judge did not allow for that particular one to come in, but did say defendant intentionally violated the court order by making public attacks on the judge's law clerk, despite 2 prior court orders not to do so. That was approved, so that can be used if Mr. Trump decides to testify. Next, defendant violated court order by failing to remove untrue, disparaging, and personally identifying posts about the court's principal law clerk from the website here. The judge said that was also permissible. Here we have defendant committed repeated and persistent fraud in the transactions of business by fraudulently misstating the value of his assets. That is not one that is coming in. Now, again, everybody, the caveat here is I have not read his order. He read his order to the court. I don't have the transcript. I'm just giving you an idea here of what's going on. But this is based off of the reporting that I've seen in multiple different places. What was allowed and what was not allowed, okay? So if I am making a mistake, I apologize, but I am trying to be as accurate as possible without actually having the order in front of me. So one of the next cases was we have 2 Carroll v. Trump cases, right? Carroll 1 and Carroll 2. There are pieces that have been allowed in. So that the defendant actually defamed E. Jean Carroll in public statements, that is being allowed in. And the false statements were made with actual malice. So that's also important. Those statements are allowed in. The actual amount of the compensatory award, from what I've seen, that amount is not allowed. He has also said any discussion about the actual assault itself is not to be permitted. That would be too prejudicial, again, to the jury. And here we also have more public statements that were made without malice in a defamation as well, but not the amount of damages. So that was also permitted. The sanctions, they sanctioned in the Clinton case, his attorneys were sanctioned almost $1 million. That's not allowed to be used here. Next up, we have the People v. the Trump Corporation. So we have a very specific allowance for this case. Any kind of showing of the repeated and willful self-dealing of transactions is allowed. The actual language here that the state set out, though, itself is not being permitted. So they're being very specific about that as well. Underlying facts, again, have to be very careful about that as well. The last piece on this back page was a stipulation. The defendant stipulated to the dissolution of the Donald J. Trump Foundation to resolve claims by the New York Attorney General of breach of fiduciary duty and waste, failure to properly administer charitable assets, improper political activity, unlawful coordination with the Trump political campaign, and repeated and willful self-dealing transactions. That is allowable as well. So, thank you so much. That stipulation, again, that was an agreement that he made. That is also allowable. So just a quick overview of what those Sandoval holdings were. We will have an official ruling from the judge at some point, and I will go through that when we have it. But again, that just gives you some idea. Explain prejudicial to the, we missed it. Prosecutors can do a lot with the, oh, absolutely, absolutely. And again, the whole thing is that, your prior bad acts usually can't be used against you unless they're acts saying that you are acting fraudulently or being untruthful. Can you explain prejudicial to the jury? A lot of that seems like it's showing a pattern. So great question. And we do have rules on patterns. We can show a pattern of conduct, but we have to be really careful about that. So we have rules on habits, evidence. We have to be careful how we use that. And then we have rules on modus operandi too, which is another way of kind of going into habit. These are more of different kinds of evidence than the prejudicial piece. So when we're talking about prejudice itself, that's a different animal. The prejudice, I think the best way that I can explain prejudice versus probative value, and it's difficult. This is a very difficult concept to nail down for everybody. And so it's probably the best way to describe it is if you have a crime scene photo, and it's a crime scene photo that can show the jury what the crime scene is, but it is so descriptive, the photograph is so shocking that the jury would only notice how shocking the photograph is rather than this is a picture of the crime scene. So it is a picture of the crime scene. That could be probative. That could be helpful for the jury. But the fact that it's so overwhelmingly graphic could prejudice the jury. So the only thing they're going to think about is that photograph. So there may be a 6-month trial, and the only thing they have in their mind is this picture of the crime scene because it was so shocking. So that's the kind of prejudice that we're talking about. Prejudice where the showing of the crime scene in this particular photo does not outweigh how prejudicial it would be in the minds of the jury. And so we have to find another way to get that same evidence in front of the jury, but just in a way that's not so shocking. Does that make sense to everybody? We developed worst ones. Oh yeah, exactly, WebDub. I mean, there can be, and when it comes to this issue of prejudice, the judge has ruled that the Access Hollywood tape is too prejudicial. Oops, let me bring this back again. Access Hollywood tape is too prejudicial to show that tape. Now, the transcripts can be read, the information can be given to the jury, but to actually see the tape and hear the audio would be so prejudicial that it outweighs how helpful it would be as a probative piece of evidence. All right, so this is one of those concepts in our rules of evidence that everybody gets frustrated with, and it is one of those that is hard to really nail down. And it's just because it seems counterintuitive. It seems like you want to give all the jury all the evidence that you possibly can and let them decide. But the other thing too is that we recognize juries are humans, and if you give them something so shocking, and one thing is shocking and 5,000 things are not, what are they going to pin their entire verdict on? And, we don't want one photograph to be the difference between a yes or no when we could give them the same information a different way that wouldn't be so shocking to them. You fight this issue on almost every case. Well, yeah. I mean, I would say that 403 objection is one that we use a lot, especially as defense counsel. We use quite a bit. As a prosecutor, it's just like, oh my gosh, 403 again? Like, come on, people. Let's move it along. But it's something that you want to be careful of. One of the other examples was that I tend to give is if you have, let's say we have a homicide, and I'll just give general terms, everybody. We have a homicide, all right? And this is based off of a real case. And the victim was wearing a sweatshirt. And so in order to see what the victim was wearing and to kind of put the whole case together, of course, the jury would want to see the sweatshirt. So it's one thing to see pictures of the sweatshirt. It's another thing if you put the sweatshirt in plexiglass so that it's a full T sweatshirt and you can see the outline of the bullet hole, right? So you can see through the sweatshirt because of the way it's being presented. So we have this idea of, yes, we want to see the sweatshirt. Yes, we need to know. But is this visual so prejudicial that our jury is not going to be able to look at any of the other evidence? This is the only thing that they're going to notice because of how it's being presented. So, we want them to look at all of the evidence. We don't want them to base the whole case on one thing. So that's what we're talking about here. Something that, again, is just so shocking that our jury cannot put it in and weigh it out with the rest of the evidence. Jury member, oh my gosh, yes, especially on our child cases. Those are particularly difficult. There are things I have seen I will never be able to forget. So for me, it makes sense. It makes sense. All right, so we had those rulings come out, and he went through the Sandoval holdings there. We will have full breakdown of that once that has been published. So at this point, we have the jurors entering. I'm just going to walk you through again. And as the jurors are coming in, the judge is instructing them on, or once they come in, the judge is kind of setting out the outline for what to expect. So he's going through and he's saying, look, everybody, we're going to start with oral arguments today. So kind of walking them through, because again, he's kind of the one keeping everybody comfortable, at least with what we're doing. So here's some quotes from Judge Merchan today. Quote, "You must decide this case on the evidence. Remember that whatever the lawyers say is not evidence." So he's trying to explain in our opening statements that what we're saying are persuasive arguments. We're not presenting evidence. We've got two primary types of evidence: direct evidence and circumstantial evidence. We've talked about this before. Direct evidence, we have witnesses, various pieces along that, and then circumstances are evidence surrounding the situation to help put together what actually happened. So direct and circumstantial, and then a third category for trial we call demonstrative evidence. That means something we've created in order to make it easier for our jury to understand what's going on. Something like this. If we put a diagram together and show it to the jury, this would be seen as a piece of evidence. We would call this demonstrative evidence, again, helping to show the jury what's happening. So what he's saying is, we have evidence. We're going to show you evidence. But these oral arguments, these oral statements, these are not evidence. These kinds of, when the attorneys come up and start talking to you, they're trying to be persuasive. They're going to not be giving you evidence. So whatever they say is not evidence. And I think that's a really important piece to understand. And a lot of people may feel super persuaded by the attorneys, and that's our job. That's what we do. We're there to persuade people. But on the other hand, they need to look at the evidence in order to come to their verdict. So that was something that he was really careful about emphasizing. Like, they're going to come up and put on their dog and pony show, and that's their job. But the evidence isn't being presented yet. So even if they tell you something's going on right now, it doesn't mean that that's actually what's going on. So I thought that was really good. He also made sure to say that the defendant is presumed innocent throughout the entire proceeding. The defendant is presumed innocent, and the burden of proof is on the state to prove beyond a reasonable doubt that he is guilty, and that presumption does not shift. So that burden does not shift, meaning at no point does a defendant have to prove that he's not guilty. It's up to the state to prove beyond a reasonable doubt that he is. That's the job of the state. That's the job of the prosecutor. It's not the defendant's job to do that. So he said the burden of proof never shifts, so keep that in mind. The burden is always on the state. I like how Judge Merchan handles this courtroom as well. So a couple of more things he said to the jury. He said the jury must find the defendant not guilty if the burden of proof is not met. That's their job. The verdict can't be baseless or based off of speculation. Notes are allowable, so some of our jurors did want to take some notes, but you cannot rely on your notes verbatim. So you can take a few notes if you need some notes, but you need to really just be paying attention to what's going on. Is it normal for judges to go over all of these things at the beginning of the trial? Yes, our judges always do. And depending on how experienced our judges are, it depends on how their spiel goes. But every judge has a spiel and tells all of our jurors how it goes, how it breaks down so that our jury knows. So next up, he said, use your varied life experiences in evaluating witnesses' credibility, because of course there's going to be a lot of talk about credibility of our witnesses, so just use your own life experiences. Witnesses can only testify about matters of personal knowledge, so that's another clarification point. So personal knowledge is something that is part of our evidentiary rules. A witness is only allowed to testify within that. That means if they're outside, you can object to that. Now, he's not going to sit and go through the rules of evidence with the jury. He's just going to say, look, they're testifying based off of personal knowledge, just so you know, just to clarify that. Also, he clarified too, when will the judge decide that the jury must be sequestered? So, we've talked about this before. The level of sequestering is on a spectrum, and it depends on what's going on. Once we get to a point, if they're deliberating, at that point, once all the evidence has been presented and the jury's been set to go and deliberate, this could be a fully sequestered situation where they are put up in a hotel. They're not allowed to see anyone. They're not allowed to do anything, full on sequestering until they reach a verdict. That could happen. If something odd happens in the middle of the trial, that sequestering may need to happen to some degree as well. But at this point, we're not sequestered to a point where they cannot go home at the end of the day. So it'll depend on what happens in the case, which level of sequestering will be needed, and that's based solely on what's needed for due process. So let's see, what's next? He said lawyers may not comment on witnesses' testimony. They can't comment during witnesses' testimony, even though it happens in TV and in the movies. That does not happen in real trials, which I thought was hilarious. A fun way for him to say that. Also, he said, you have promised to be a fair juror. Alternates, by the way, will only be substituted in an extraordinary emergency situation. So that's something he cleared up too. Like, we're not just picking alternates like, oh, I can't do this anymore. No, he's like, extraordinary emergency is the only situation where he would pull in an alternate. Also, jurors must report any attempts to influence them. So if anyone tries to influence these jurors, they need to tell the judge about it. And he's open to that. Can they take their notes in the deliberation room? That'll be up to the judge to decide. Everybody's a little bit different, so it just will depend. I know they won't be able to take them home with them. Usually they collect the notes at the end of the day, and of course after deliberation, everything gets taken and put into wherever it needs to go. But that would be my bet on that. Also, he told the jurors, do not research this case. Do not do your own research. Don't do your own investigation. And here's another quote. Only you have promised to be fair. No one else has been so qualified for this trial. So again, really putting onto the jury this, sense of like, this is so important. You are the ones who are going to decide this case. And, we've got to make sure that you're paying attention and you're coming in and taking care of business. If during deliberation can the jury ask for a readback of the court transcript, they can ask for anything that they want. But the judge will decide whether or not they will get it. So if they ask for a certain testimony to be read back or certain exhibits, if the judge approves, they can see it. If the judge does not approve, then no. And that can happen several times. I've seen cases where the judge is like, they've asked for something and the judge has said, that's not actually even part of this case. So no, you can't have that. But they can ask for it. They can ask for it. All right. So that was the introduction, everyone. He spoke to the jurors and set that out. So then we move on to opening arguments. Now, I will use the term opening arguments, oral arguments, opening statements interchangeably because those words just all mix together for me. But anytime I'm talking about opening statements, I'm talking about the first presentation by the attorneys. All right, everyone, so forgive me there. After closing, our alternates excused or only after the verdict. So typically, once the jury is set to go deliberate, the alternates are dismissed. That's typically how it goes. But, it depends on your jurisdiction. But that's typically how it goes. here. Oh, absolutely. All right, everyone. So here we go. We're going to start getting into the opening statement. The state always goes first because they bear the burden of proof. Then the defense counsel goes, and then the state can come back with a second opening depending on your jurisdiction and what's going on. In my jurisdiction, if it's a huge case, we'll take our second, as a prosecutor, we'd take our second opening. But if it wasn't a huge case, we would waive our second opening. As defense counsel, one of the worst things would be when the state would waive their first opening and then we would have to start with our opening. And we're like, wait a minute, this is backwards. But anyway, I digress. But the state's going first here. So I'm going to assume that this is state's attorney here, and then this is defense counsel. So we'll go through what they were talking about a little bit here. So we've got Assistant DA Colangelo, I think is his name. He's the one that was presenting opening statements today for New York. Couple of quotes I'll take you through here. The first one is, quote, "This case is about a criminal conspiracy and a cover-up." So that's how he's starting his opening. He's like, this is a conspiracy case. Next quote, "The defendant, Donald Trump, orchestrated a criminal scheme to corrupt the 2016 presidential election. Then he covered up that criminal conspiracy by lying in his New York business records over and over and over again." So he's setting the stage again. We've got to have this idea that this is all about the election interference. So next up, his job is going to be to set the timeline, which he went through and said what happened when. So this happened, this happened, this happened. Timelines are going to be very important here, especially because of the Stormy Daniels and the Access Hollywood tape. The timing is really key. So he set that timeline up. Next, he started to go into a little bit about Michael Cohen here. So Michael Cohen made the hush money payment at the defendant's direction, and he did it to influence the presidential election. Again, he's just really emphasizing the mens rea, the intent behind, like why all of this happened to begin with. Thank you, James. Appreciate that. Trump said in business records that he was paying Cohen for legal services pursuant to a retainer agreement, but those were lies. There was no retainer agreement. So you can hear that persuasive argument in there. This is the evidence you will see. So he set out then the evidence that he plans as the state to put on, which is very typical of an opening statement. So he says he will prove the intent to defraud, the intent to commit another crime, aiding to conceal the commission of that crime, and making and causing a false entry in the business records, and documents and evidence needed to show falsified records. So this is his roadmap. This is what he's going to show to the jury, setting that out. Next, he said, quote, "Whether this was done to protect and prevent Trump's wife, Melania Trump, from finding out about the affair or done for political purposes, it doesn't matter. Even if half private, half political, it doesn't matter." So he even just right away said, let's get it out there. Let's talk about what the defense could bring in as possible reasons for this, possible justifications. And so next he said, we will hear the tape between Trump, Cohen, and McDougal. So that was the other lady involved. We will hear the tape. So now he's kind of introducing this idea to the jury of the evidence they'll actually be seeing. And one of the things, too, when we present this kind of information to the jury, everyone in an opening, is we kind of show the jury that we're trustworthy. So he's saying, I'm going to show you this tape. And so when he shows you the tape, it takes you back to that moment. Like, well, he said he was going to show it to us, and he did. So there's kind of this trust situation occurring. And so that builds rapport also with the jury, even though after this, they don't speak to the jury anymore until closing. Next, he talks about the role of the Access Hollywood tape, and then he read the words from the transcript of the tape, everyone. So he read the Access Hollywood tape transcript in his opening statement. Yikes, I'm not going to read the tape transcripts, everyone, but he read it. Can you imagine? I mean, how important do you think that was? Was that a good strategy for him to just read the actual words, the language itself, which he was allowed to do? They had fought about this on what they could use that Access Hollywood tape and how they could use it. And he read it right in his opening statement. Yes, I thought that was a genius move. And of course, if you've got it, read it, do it, get it out as many times as you possibly can, for sure. So he did read that in. That's in the record. Also, he talked about this text that came between Keith Davidson to Dylan Howard. So there were these two fellas, right, involved in this catch and get rid of it scheme for the National Enquirer. And one was an attorney, one was one of the editors at the National Enquirer. And one of the texts that Mr. Davidson sent to Mr. Howard was a quote on election night. And he said in his text, "What have we done?" Like, that was like, oh my gosh, that's another really a moment where you just pause, where someone actually involved in the scheme is having these second thoughts and saying, oh my gosh, what did we do here? What did we do? And acknowledging that maybe this wasn't the best of ideas. Maybe this should have been thought about better. That will be a footprint in the juror's mind. I agree, Norma. I agree. Exactly right. And I mean, and again, this was already ruled on. If he had just brought it up and just sprung it on everybody in his opening statement, that could have been a problem. But this was already agreed on by the judge. Everybody knew that this was allowable. I know it's called a catch in a different word, but I can't use the KILL word for the algorithm here, everyone. So forgive me on that. Also, he explained that the reason why the payment was double the price was in order to make it look like it was income. Next, he went into Michael Cohen and he said, look, he's going to be brought up and he's going to be testifying, and he's a well-known figure in this situation. And the defense is going to try to get you to disregard his testimony, but I'm asking you to keep an open mind. So I thought that was really good as well. I mean, he's already addressing the credibility issue that he's going to have with Michael Cohen. As we all know, there's going to be some credibility issues, and he's addressing it. He's like, look, I know there's going to be some problems. I'm asking you to keep an open mind. So, yes, Catch and Kellogg. Yes, everybody, I apologize. Oh my gosh. All right. So that was the summary of that 1 hour opening statement, everyone. Now, again, I'm not going verbatim except for a few of the quotes, and there was quite a bit more involved here. Oh my gosh, thank you so much. I appreciate that. There was more involved, but I feel like I hit the highlights here of really what his strategy was, what his persuasive argument was as the state, so putting on the case here. Yes, a full hour. Now, that's a long time. But again, I think because he was pulling in reading the transcript, that would have taken a little time. And then, also this idea of kind of trying to rehabilitate the witnesses before he even pulls them on, that took a lot of time too. I don't know. I heard somebody saying, I don't know who it was or what they were on as far as news reporting goes, but someone had said, in the old days, we used to have to be real quick with our oral arguments, and now these young attorneys, they just go on and on and on and on. And I thought to myself, I'm like, really? I don't remember that. I always figured, it takes as much time as it takes. Like, you set your opening statement out, and, it takes as long as it takes. So that's what was going on during his opening statement. So next up, let's get into the defense opening statement, everyone, because of course we have to have both sides of the story. That's always the way that we have to do it. So I've got several sketches here. Again, thank you to the sketch artists. We're very thankful for our view inside the courtroom. All right, here we go. So here is the defense, and they came in. Theirs was about half the length, so they only went half as long. And again, the defense doesn't have to put on a case. It's not their job. It's not their job. The burden of proof is on the state. Their only job is to have a defense. So part of their defense could just be discrediting the states. They don't even have to put witnesses on if they didn't want to. That's not even required legally. All they have to do is defend what the state is putting out there. So kind of keep that in mind. All right, here we go. So the defense counsel is saying, quote, President Trump did not commit any crimes. That's his starting. Now, I know that's a trigger for a lot of people. All right, I know that's going to be a trigger. But that's what he said. I'm going to be very interested to actually get the full transcript of this one. Next, he set out, just to be clear, he set out this idea of calling him President Trump. Now, that's been a huge thing that we've talked about before, everybody, whether or not, Mr. Trump should be called President Trump. He started out with a bang and was like, he is President Trump. This is what he said to that. He said, he and his team will call him President Trump out of respect, a title he has earned because he was our 45th president. So he made that statement just right away to the jury. He's like, look, we're going to call him President Trump. We're doing that out of respect. This is what the team does, and that's how we're going to proceed. So just right away, he explained why he was using the title that he was using and kind of set that out. Next, he said there's plenty of reasonable doubt, which of course is what you have to say as defense counsel. There's plenty of reasonable doubt. The 34 counts, ladies and gentlemen, are really just pieces of paper. So I'm not sure, everybody. There's a few moments in this opening where I'm like, what? But that's what he said. All right. He said, quote, the 34 counts, ladies and gentlemen, are really just pieces of paper. I love that you do this. Thank you. Oh, you're welcome, Jacob. Oh, I'm happy to. All right. Next, he said, quote, none of this was a crime. Anyone seeing a pattern here? Anyone getting a theme? Next, he said the payments to Cohen were not a payback. Next, he kind of went into this idea that Mr. Trump is really a frugal businessman. So he talked about, how he's very careful with his money as a businessman in order to set up his next theme, which I thought was really interesting. Call himself the Eastern Run if he wants. True. So I thought a great point that I had not even thought about at this point, he had said, quote, would a frugal businessman pay $420,000 for a $130,000 debt? Which, how fascinating is that, everybody? Oops, sorry, everyone. I'm having to do it's hard to put the puzzle piece in when I have these nails on. Okay, there we go. Sorry, verifying. So he said, oh my gosh, again, there's several pieces in here that are just, it's a lot. Quote, would a frugal businessman pay $420,000 for a $130,000 debt? So, of course, as we know, Michael Cohen was paid $420,000, and the state said, well, that was to make it look like income. And, Weisselberg was like, this is to help with tax stuff and blah, blah, blah. But he's saying, well, why would he pay $420,000 when he only owed $130,000? And again, you're like, well, $130,000 to a lady, a lady to cover up the business, that was going on. I think it's a very good point that he brought up because it's incredibly practical. If you think about it, if you just look at this as dollars and cents and you take out the aspect that it was a lady that was, with the shenanigans, you move that to the side, it's a $130,000 debt that he needed to pay. Why would he spend $420,000 to pay for that when he is such a frugal businessman? I think it's a good point. I think it's a very good point. I think another good point would be, though, how the debt itself was gained. So it's like we're not just crunching numbers, though. We're actually looking at what the debt was. So I thought that was a good one. All right, next up, quote, you'll learn that President Trump had nothing to do with any of the 34 pieces of paper, except he signed the checks. So he's continuing on by minimizing the counts. So each count is just a piece of paper. It's not a criminal felony charge. It's just a piece of paper. And he just signed the checks. So I thought that was really good too, because he's minimizing how there are 34 violations of felony law here. I thought that was really, I thought that was good. Maybe that's another theme. So next he said, quote, "The reality is Mr. Trump is not on the hook. He's not criminally responsible for something Mr. Cohen may have done years after the fact." So there we go. Let's toss Mr. Cohen under the bus. There's going to be a lot of that going on. Next, oh my gosh, this next one, everybody, it's a lot. This next one's a lot. Oh, thank you so much. Oh, I appreciate that. Here's another one. Insulting the intelligence of the jury. Well, he's definitely minimizing, right? I mean, that's definitely, I don't know, maybe that's a strategy though. Like one of those, hey, we're just like you. We're just, we just paid $130,000. Why would we spend $400? I don't know. The next quote I have, so it's a lot. Quote, "I have a spoiler alert. There's nothing wrong with trying to influence an election. It's called democracy." Oh my goodness gracious. Oh, that's the quote that just gets me. So let me read this quote again. Direct quote. Quote, "I have a spoiler alert. There's nothing wrong with Trump trying to influence an election. It's called democracy." I know. First of all, what? Spoiler alert? What? Is he trying to be hip? I know. Yikes. Exactly. I know. That's a lot. That's a lot. That one was a lot. All right, here we go. Here are a few more bits. Next, quote, "Entering into a non-disclosure agreement is perfectly legal. You will learn that companies do that all the time with some regularity." So that's another quote. So we're gonna have a lot of evidence being presented about companies and non-disclosure ones. Next, quote, Stormy Daniels' false allegations that she had an affair were sinister. It was an attempt to embarrass President Trump, to embarrass his family. So that's another quote as well. Trying to embarrass him and embarrass his family. So that one is always, this one's a little bit more difficult, because you have to think, on the other side of that argument. He's like, oh, she's just trying to embarrass him. Well, why? Why? What is it that she had to gain? Like, if you want to go down the money road, go down the money road. But if you're saying she's doing this, out of some kind of like wicked sense of trying to embarrass someone, like, there are easier ways, to embarrass Mr. Trump. There are way easier ways to embarrass him than what she has gone through. I would just throw that out there as a piece. Yeah, so he's definitely going after the credibility of Miss Daniels, of Stormy Daniels here. So that was another quote. He also said that Cohen wanted a job in the administration in 2016. So now he's going after Cohen. Next, his quote is about Michael Cohen. "He's obsessed with President Trump even to this day. He has a goal, an obsession with getting President Trump. I submit to you that he cannot be trusted." So that's his take on Michael Cohen. So we've got Stormy Daniels is just sinister and trying to embarrass Trump. And Mr. Cohen is obsessed with Mr. Trump and obsessed with taking him down. Right, everybody but me defense, absolutely. And that's how you go after their credibility, right? So these are, it looks to me like this is how they're starting their whole argument about discrediting these witnesses. All right, so next up, we've got another quote regarding Mr. Cohen. "His entire financial livelihood depends on President Trump's destruction." I thought that was a pretty good quote. Or a pretty good point that he's making. And let me read it again. So this is Mr. Cohen. "His entire financial livelihood depends on President Trump's destruction." That's pretty good. I thought that was pretty good. Planting seeds for motivation. Absolutely, absolutely. So I thought that was a pretty good point that he made. The financial benefit that Cohen has had here. Maybe not to that extreme. And I think the opposite argument, everyone, would be like he has to, because his whole world was destroyed by what he has done with Mr. Trump. So he has no other way of making a living. So this is his only option. So that would be the opposite side of that argument if you're looking for that. The next quote is, "You cannot make a serious decision about President Trump relying on the words of Michael Cohen." So he's just straight up saying he's not reliable. And it's about democracy, right? Democracy. Yikes. Next, he goes back to Stormy Daniels and says, "She also wrote a book. She was paid for a documentary. She owes Trump $600,000 as a result of legal attempts against him." Now, we've talked about that before. I've actually even gone through that lawsuit, everyone, where her attorney had filed defamation regarding a statement she made about someone trying to harm her in 2011. And the judge dismissed the case, and she was left with court costs. So let's just clarify what that case was about. Let's be clear on the facts of that case. So there you go with that. So he brought that up as well, which I thought was interesting because I didn't see that in a motion in limine from the government. The government didn't ask that he didn't mention she owes legal fees to Mr. Trump. And I'm wondering if they could have. They didn't, but maybe they could have, and that was an oversight. Or maybe they just don't think it's relevant, or maybe they're like, yeah, here, let's hear it all. Let's hear all of the information. I don't know. Let's ask the chat, everyone. Would you have asked the judge to withhold the information that Daniels owes Trump legal fees? Would you ask the judge to withhold that information? Yes or no? Yes or no? Should we withhold that information? Yes, no. Yes, no. No, no, no. No and yes. Okay. No, well, right. Okay. So far, no and yes. Right. I'm just not sure, again, how damaging it is. But I think that, oh, thank you so much. Thank you for the orange. I think the defense counsel may think it's more damaging than it actually is what I'm wondering. Conflict of interest, the defendant isn't the witness. True. No, but with clarification. Okay, what does it have to do with anything? Well, that's a great question, and it is public knowledge. Also a great point as well. It would be part of their defense, right? Could be. Going to throw everything. Right. And that's what's happening. And I think he's kind of taking a swing at Stormy Daniels here with this, legal fees that are owed here in this situation. But I'm not sure that it's going to have the kind of impact that he thinks it will. But it was important enough for him to put in his opening statement. So not relevant, right. You don't want to want to withhold from the defense can use against the prosecutor. Right. And that's, of course, the best strategy is to, just get everything out in the open. But in it, with the motions in limine, you can also request those kinds of things as well. I need to go back through the state's motion in limine and look and see what they did actually ask for again. So I'll need to review that, for fun, because that's what normal people do. They did object, Dash, and I'll go through the objections next. I'm glad you brought that up. All right, so next up, we've got, he starts talking about Mr. Pecker, all right? So, first of all, Mr. Pecker, let's just clarify. Just keeping everybody here in the loop. Mr. Pecker, all right? You may not know Mr. Pecker. He's also known as the National Enquirer dude. All right. So he's the AMI, the National Enquirer editor. He's also known as Mr. Pecker. Okay. So as we go through this, just keep that in mind. I think I had spoken to somebody earlier today and I said, "Oh, Mr. Pecker." And they're like, "Who is that? I don't even know who that is." Right. No, he's for real. No, his name is Pecker. His name is David Pecker. He's the publisher of the National Enquirer. All right, he has allegedly paid Karen McDougal $150,000 and Dino the doorman, or Dino the doorman, I don't know, Mr. Doorman, $30K because of the love child. So that's Mr. Pecker. So they do start talking about him in opening statements. So let's talk about that. So here he starts saying, with regards to Mr. Pecker, all right, quote, "It's not a scheme unless a scheme means something that doesn't matter. That's not illegal." That was the next quote. Like, what is he even saying here? Like, what? Let's read that quote again. As soon as I wrote this down, I was like, is this guy okay? I'm not sure. Mr. Pecker, yes, his name is David. Listen, everybody, I'm not going to say his name too many more times, all right? Here's his name right here. I know my R's are odd, so it sounds a little different. Oh my gosh, I know, I can't help it. All right, here we go. So that's the quote. "It's not a scheme unless a scheme means something that doesn't matter. That's not illegal." All right. Listen, and then he starts saying, when Mr. Pecker gets up on the stand to testify, he tells the jury, listen to what his motivation is to sell magazines. What's his motivation? So pay attention to that part of his testimony and use your common sense. The next quote he has is he's kind of starting to wrap up here. He said, "You told all of us, you told the court." Hold on, let's back up again. "You told all of us, you told the court, you will put aside whatever views you have of President Trump." So again, he's addressing the jury and saying, you said you'd put aside any of your previous thoughts, and so I'm going to request that of you. So we do have that in that situation. So that was pretty much it for defense's opening statements here. And then we have him just pointing at Mr. This is one of my favorite sketches. He's just like, la, 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 and he's just pointing at him. It's cracking me up. So here's another great sketch. And then, of course, we're back to the state. So oh, my goodness. Here's the state. And then here's Judge Engoron over here. Like, oh, my goodness. It's going to happen. So here we go. So that's the state. Excuse me. And then this is defense counsel. So let's take a minute because the state had some objections to I'm going to get oral and opening arguments, opening statements. They had some objections. So let's talk about that. So these are all objections brought by the state here. The first objection that the state had was to the defense counsel saying that lawyers negotiate non-disclosure agreements and payments. So they objected to that. They said that's incorrect, and Judge Merchan sustained it, meaning it was allowable. It was allowable. Yes, it is rare. It is rare. It's not very often that we have objections, especially from the state, actually, because usually your objections are to keep a good record for when you're appealing it, because you can argue, oh, they screwed up during opening statements, and here's the record for it. But it's a bit unusual to have it done on this side, on the state side. So I thought it was a bit odd, but go for it. Next, the state objected to the defendant saying that Stormy Daniels was trying to extort President Trump. So he objected to that as well, to that negative connotation of Ms. Daniels. He objected, and Judge Merchan sustained that. So that was allowed in as well. Next, he objected to the quote, "There's nothing illegal about entering into a non-disclosure agreement," end quote. They objected to that as well, and Judge Merchan sustained and said that was allowable. So that's a pretty big objection, in my opinion. If someone's supposed to say, there's nothing illegal about entering into a non-disclosure agreement, like that's just patently false, but whatever. So he was objecting again. And then we had two more objections from the state regarding Michael Cohen lying. and clarification, because we do have a motion in limine on that. And so they've got to be kind of careful with how far they push that piece regarding Michael Cohen. And they objected, but the judge sustained it. So again, it was allowed in. And then the next thing that happens, everyone, is that the state calls Mr. Pecker. Oh my goodness. So now when the state calls in their first witness, we talked about this before. Their first witness needs to be kind of their strongest witness, and the one witness that can kind of set the stage. I don't understand why it was allowable if objection was sustained. So I would, if the objection is sustained, it just means, hold on everybody, let me double check the looking here. Let me see, did I say it backwards with overruling and sustaining? Hold on, let me double check my source here. Because I'm looking at so many different sources, I may have mixed up what the comment is. So let me go back in here. Just 1 second, everybody. Oh, let me see if I can find my, yikes. Okay. Let me check my source. One of my sources here. All right, one of my sources is saying sustained, and then my other source is saying, wait, hold on here. Okay, well, this other source is saying then it was not. I mean, it was sustained on the record and it was moved on from. So technically a sustaining means that the objection's good, but we just kept moving on in the oral. I thought I heard 2 overruled, 2 sustained. Yeah. I'll have to go back through everybody. Now I'm curious, because with my objections, what I have is that they were sustained, but that they just kept moving forward on that. So I'll have to go back and double check, everyone. I'll have to double check it. Yep. Let me go back through. And actually, I'll do a full post on that because I'm really interested as well. So let me pull up the objections and see what happened. I really hope I can get a peek at those transcripts because it's hard to tell. No move to strike. Yeah, that's the other thing too. Because if we're sustaining and they're just moving forward. Thanks for checking. Yeah, I'm glad you told me. Okay, so they're up now. Let me double check, everyone. Let me double check on the objections. All right. So either way, with the objections, the best thing you can do is you just make a record that the state says, I'm objecting to your comment that NDAs or non-disclosure agreements are illegal. I object. And with the court saying your objection's good, it's not going to change anything because the state can't appeal any of the issues. The only person that can appeal is the defendant. So if it's overruled, then at that point, it would be not in the record, but it wouldn't matter because that would be for the defendant. Transcripts are expensive. Oh, they are. They are. So we're in a weird situation. Because we kept going on it. So there would be an objection, then there would be a sidebar, and then they kept moving forward. We're not very good for the defense. Yeah, it's a good question with the objections. Let me go, I'll make a post on it, everyone, and kind of clarify a little bit. $7 to $12 a page, what? Oh my goodness. Wouldn't be for the jury. Right. Well, and that's the other thing too. If we've got an objection put into place so that the jury noticed at which point the state was objecting, the ruling that the judge made wouldn't be as important as the fact that the state objected. It was to show defense the state's ready with objections. That could be, Aaron. That could very well be. That could very well be. That's going to bug me now. No, cat juice, no. It's going to bug me too. It's going to bug me too. All right, I'll put something together. I will work on that. I'm like looking at the clock. I'm like, I'm going to get that post done tonight. We'll get it sorted out. We'll get it sorted out. It sets the table. Right. It doesn't, yeah. I mean, again, if you're, and that's why it's so weird because it is unusual to object during oral arguments or during opening statements because there's not really much you can do. Again, because those kinds of objections, if they're coming from the defense, it would be different, but they were coming from the state. All right, we'll take a look. I'll take a look at that and then put together a post on the objections because I'm really curious now. So just as a quick intro then to Mr. Oh, thanks, Kristen. As a quick intro to Mr. Pecker here, he was the first witness that was called. We had, batted around who we thought was going to be the first one. And, I don't know. I had thought maybe one of the secretaries would go first or even Cohen because he knew most of the case. But I came in off of the idea that Mr. Pecker was friends with Mr. Trump. And at this point, hello, he had signed an agreement. And I think that's a key piece. So he had signed an agreement that he would not be prosecuted in exchange for his testimony. So that kind of changes things a little bit. So he definitely has, he's got the most to tell. He's got the best story to tell to the jury. So he would be a great story teller or a great person to put on first. He said hi to Trump. Lisa, I read that he passed the table and was like, hey, I love that. I think that's great. Good for him. An expert to opine the legality of NDAs. It sounded like, JK, that's a good point too. It sounded like the defense was really going to put on a lot of information about the NDAs, how corporations use it, experts on it, what they are, and so on. It sounds like they're really going to go down that road with the NDAs and really, really take that. I'm not sure that that's good or bad. I just think it's interesting. Is the defense privy to the witness list? Absolutely, Amber. So, of course, all the witnesses that are going to be called have to be given to the other side. You have to. That's just constitutionally protected. What order they go in, that's a different matter. But all of those witness names, they probably already have them at this point. And if there have been any reporting or depositions, typically if depositions had been taken or any statements that they had made to anybody, all of those had already been gone through, included in the trial binder. I use the term binder, but it's, I'm sure, electronic, but included in all that and tabbed out so that if anything they testify to is contrary to what they have already stated, then that would be used against them. So all of that would already be done way in advance. So they have all of that information. Trial catalog. Yes, I think that's perfect. That's perfection. We will call it that from now on. The catalog. They only find out the night before who will be on the stand. So that's another interesting thing about this case was because of these questions regarding the safety of the witnesses and what has been said extrajudicially, there are some questions about whether or not the state was like, we don't want to tell you who's going to be on the stand because we don't know what you're going to say about them. And we're worried, which takes me to tomorrow, everyone. So as a reminder, as a friendly reminder, let me pull out my calendar here. Let me see. Here we go. Here's our calendar. So for tomorrow, we are set before trial starts. So before we're even calling in the jury, we're going to have the gag order hearing. So the state of New York has filed for violations of the gag order. Originally it was 3, now I think it's at 10, but I've not seen their newest filing, including those new 7. I've not seen that yet. But they're going to have a hearing on it. And Judge Merchan's like, let's talk about it then. Let's talk about it. The state's asking for $1,000 per violation. And we've got, all of the violations put together in a packet of the different posts that have been done. But that will be done first thing tomorrow. So that will be before court starts. Now, again, just as a quick side, when Mr. Pecker was called up to the stand today, we just had a very quick beginning of an introductory bit. So he just was introducing himself, kind of what he does, and those kinds of things. So his full testimony is really going to start tomorrow. So the information that he has to give us will be more in depth tomorrow. Oh, thank you so much. So that was what was going on in the morning. So first of all, we'll have sanctions questions, and it'll be interesting to see what the judge rules. If he's like, okay, I'm going to just rule from the bench, or is he going to say I'll have an order in by the end of the week or whatever. Because you don't want to have a judge coming in and be like, yeah, here's huge sanctions, and then you're going into your jury trial in like an hour. That's a tough break. All right, next up then we have some filings that need to be done by Mr. Nada in the Florida case as a reminder. And then we have oral arguments set for the U.S. Supreme Court for SCOTUS on that immunity question. So that D.C. case on that absolute immunity issue regarding the president. So that's set for the 25th. And then we have the Discovery and the Blessing Game case, which is the civil partner to the D.C. criminal case going on. So there's a lot going on this week, everyone. It's very busy. You're going to be live on Thursday to listen. That's a good question. I'm thinking about that right now. I'll have to see what's going on and how I'm going to work that. I've got a few things going on, so I'm leaning towards yes, but I'm not sure exactly how I want to go about doing it, but I will definitely be on at some point. I'm just not sure the timing on it before, because I did the timing. Oh, I did a great live with a dear other creator who's fantastic, and so he and I did a live together, and that was really fun. So we'll ask him and see if he wants to join. If we can do that together again. How long do you think it'll take them for SCOTUS to rule on that? I don't know. At this point, they'll have to do it before they're out for the summer. I would say they would have to get it done, or I think Justice, Sotomayor's head could explode. If it's not done, I think we would have. She needs a fruit basket, everybody. So I think we'll have it done here by, yes, formerly known as Umbellicose. I've got to practice saying his new name, man. I'm struggling with it. But yeah, I think we'll definitely have, and yours too, Chella. No, no, we'll definitely have something in, but before they leave for summer, I would imagine. She needs something. Why does SCOTUS get the summer off? Well, I think in the past it was so that everyone could, hide from the yellow fever. But nowadays, who knows? I'm not sure exactly. Check your messages will do. Absolutely. Out for the summer. Yes. So they do have breaks throughout the year. They do have a break in the summer, and then they come back, and then they're out in October again. So, and, they do have several breaks throughout the year. Just like Congress. Congress has multiple breaks. It seems like all the time, but, whatever. Whatever. He used to drive his RV. Yeah, I don't know what's been going on with Thomas lately. He's been a little bit MIA. Right, exactly. You've got to go tour around. Oh my goodness, everybody! Dark days at SCOTUS. Dark days. It's not looking good. Oh my gosh. Yes. Special emojis, of course. Too many breaks. Well, it's a lot. When do they actually work? That's a great question. I'm not sure how we're gonna climb back. I'm not sure how the Supreme Court's gonna be able to climb out of this hole they created for themselves. So I don't know. But I think a constitutional amendment on term limits for Supreme Court justices isn't a bad idea either. So we'll see. We'll see what happens. Yeah, I don't. Yeah, he does like his RVs, but he missed oral arguments earlier, so I don't know. Now, we're also waiting for that Fisher decision, everybody. That was another one that came in front of SCOTUS recently regarding that interference with official government function question. So that was the other one in front of them. So lest we forget, we also have age limit. Yeah, interesting, though. Isn't that, I think it'd be interesting how we could put some kind of... I think some Congress and the Supreme Court need a little help here. They need a little more guidance. Nothing from Georgia. No, nothing from Georgia yet, everybody. We're still waiting. But too, the other RICO case, that huge RICO case with, what's his name? Mr. Thug, I think. I think that's still going on. Did they finish? Have they finished Mr. Thug's RICO yet? Perhaps not, but that's been going on, so that's going to take a lot of time. That's a huge case. That case is they haven't finished it yet. Okay. That is enormous. With the defendants and the facts in that case, that's just an enormous mountain of a case. Oh, has it been wild? Yikes! Age limit for pilots. Yeah. Well, I'm not sure if age is an appropriate thing because, that can really vary, but there's got to be some kind of, it seems like there should be some kind of, competence testing, right? I mean, it seems like, I don't know. Yes. Oh, yes, indeed. So we'll see. Crazy. I've been listening to some of it. Yeah, I've got to take a peek at it as well, but I've been fascinated by how things were set out in court today. I thought they did very well. I was surprised, in my opinion, I was surprised. Honestly, the only thing that truly surprised me was the quality. And just in my own personal opinion, everyone, my own personal opinion, I have been hearing this attorney getting talked up so much, like, oh, he was so great, and oh, he's tossed it all away, and blah, 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 blah. And then, looking at some of the things he's saying, I'm like, what? Like, where's your polish, my man? I mean, maybe hasn't gotten his trial legs yet, but that did surprise me. I thought he would have a little bit more pizzazz. Yeah, maybe too soon. And, openings may not be his strength. And we all have our strengths. There's different parts of the trials that you're really good at and other parts that you're like, ooh, that's really bad. And, you just have to kind of find what you're good at and go through with that. But yeah, I was a little surprised. I was a little surprised by that, but we'll see. Rudy's coaching him. Rudy, oh my gosh, Rudy, no. Oh my goodness. Yeah, I was just surprised. I was surprised. Oh my goodness. No, I don't know. I'm better with for me, opening and closing statements, I don't mind and any of that, but I'm definitely best at witness examinations. Those are my favorites, direct as well as cross. So that was always my favorite part, was to go digging. Always my favorite part. Like, really? Let's keep going. So, but that's part of my favorite part of being a lawyer. I don't understand what happened at the bond hearing. Oh, everybody, the bond hearing. Yeah, I made a little note. Hold on real quick. So at the bond hearing, just in case for those who were wondering, real quick here, was he a national security guy? I don't know. Yeah, I don't really know. I was just really surprised. All right, so we're in front of Judge Ingron, and it looks like there was a decision that was made that was agreed upon by everybody. So that's good. And basically what had happened was the Attorney General was like, hey, do you have the cash to back up what you're saying? And they were like, yes, it's in this account. Everything is set. It's valid. And so she said, all right, but don't take anything out and don't trade anything. So don't touch the money that's in there. And they said, fine. And the judge said, and once a month, send the AG a statement saying the balance that's in that account. And they said, okay. So that's pretty much it. So at this point, she needed guarantee that the money was there. They guaranteed it for her in a way that made her comfortable. And that's kind of where we're set. So she's going to be getting monthly statements going into how much is in there every month, and then also none of that money can be messed with. Saturday Night Live's gonna have a blast with this. I agree. Nice nails. Oh, thank you. Yes, my little spring nails for tonight, everybody. But yeah, so that's the news from the bond situation, which is okay. I think I think we're all waiting. We're all waiting for the AG to just go and start, kicking doors down and repoing his homes. But that's not going to happen, people. There's a process. as long as we follow the process, you just wait, and then once the appeal's done, then she can start taking his stuff. Okay, it'll be fine. It'll be fine. It's happy. We're happy. I agree, Suze. She was happy with it. She was fine with it. She felt comfortable with it. And, if she's all right, then what were you surprised with? So, yeah, my biggest surprise really was defense counsel surprised me a little bit. Maybe I had just built up too much here. Maybe I built him up too much because I'm not out on the coast. I'm not on the East Coast, so I don't know the players here personally. I don't. It's a different playground for me, so I was a little surprised at this one. Yes, I was a little surprised at this one, but again, maybe he just hasn't found his trial legs yet. We'll see what happens. We'll see. I won't be. I won't be. I won't be holding it against him. We'll just kind of see what happens. Yeah, Hava seemed like she was there just to kind of, walk around. I'm not sure how much help she was at this point. Yes. Well, we can repo, but you got to follow the rules first, right? I mean, you got to follow the rules, everybody. You can't just randomly repo people. You got to make sure that you follow the rules. So, window dressing. All right. Oh, my goodness. Oh, my goodness. All right, everybody. Well, with that, oh my gosh, I'm coming up here on almost 2 hours. So with that, I will go ahead and start my sign off, my closing statements. Now, I will be back again tomorrow night, 7 o'clock, at my usual time. And I think that will work out the best. And I want to definitely go through the testimony here for Mr. Pecker. So this will be very interesting to see how this comes out. I will be taking a look to see where the transcripts are so I can take a peek at how that works. And also, I will come back with some information on those objections, everyone. I'm also very interested to see exactly what happened. Were they all sustained but nothing really mattered, or were two overruled and some sustained? And then what exactly will happen with the record then? So I'm really interested now. You've piqued my curiosity, so I will take a look at that and have a post up. So take a look, keep your eyes out for that. But it'll be Central, 7 o'clock Central. But thank you all for coming. And thank you so much to my moderators working so hard. I'm very, very thankful to all of you. I appreciate and adore all of you. So thank you for being here. And also thank you everyone for coming and hanging out and having a fun chat tonight. So, oh yes, moderators are so amazing. Very, very grateful every single day. So I'll be back again at 7 o'clock tomorrow, everyone. I hope to see you all then. It should be pretty fun. So have a great night, and I'll catch you all tomorrow.